Think about your day so far. Did you walk down a curb cut at an intersection? Maybe you turned on the captions to watch a video, took an elevator up to your office, or noticed a ramp leading into a coffee shop. We take these everyday accommodations completely for granted now, right? But the truth is, they didn't just magically appear out of nowhere. They were born from a genuinely dark history of exclusion and from some incredibly intense physical battles fought by advocates who simply demanded to be seen. And as you'll see in this explainer, these are battles that are still actively being fought in the highest courts today. So let's dive into the arc of progress and peril regarding disability discrimination in the US and take a look at where we started. To really wrap our heads around the progress we've made, we have to anchor ourselves in the stark reality of the early 20th century. Back then, the legal system itself literally sanctioned discrimination. Just take a look at this quote. This is from a 1919 Wisconsin Supreme Court case, Beatty versus Board of Education. The court upheld the expulsion of a child with cerebral palsy from a public school. And why? Because his mere presence was deemed by the school to be distracting to the other students. The court actually affirmed that schools could legally exclude students whose disabilities were seen as disruptive, unhygienic, or burdensome. So it wasn't just a social stigma, it was the actual law of the land that disabled individuals had no legal right to participate in public life, especially if accommodating them required specialized instruction or facilities. And that legal framework of exclusion led directly to some truly heartbreaking outcomes. Because public schools and society at large had absolutely zero obligation to accommodate disabled children, families were routinely advised by their doctors to just send their kids away to mass institutions. The reality of these places was largely hidden from the public until 1972. That's when a young reporter named Geraldo Rivera took hidden cameras into the Willowbrook State School in New York. The footage was just shocking. Children were living in horrific conditions. They were left naked on floors, covered in waste, receiving absolutely no education, stimulation, or basic care. This wasn't an isolated incident. It was a severe, systemic problem. It really showed the extreme end of a society that viewed people with disabilities not as citizens with rights, but as burdens to be hidden away. It was a massive wake-up call for the entire nation. Which leads us to part one of our timeline, the fight for 504. Moving from charity to civil rights. That shock to the national conscience from places like Willowbrook coincided perfectly with the broader civil rights movements of the 1970s. Returning veterans, parents, and self-advocates really started organizing. They were completely done with pity, and they wanted enforceable civil rights. So here's a rapid look at the legislative progression that kicked off. Congress passed the Rehabilitation Act in 1973. Now, hidden inside this law was Section 504, which basically said any entity receiving federal funding could not discriminate based on disability. Then, in 1975, the Education of All Handicapped Children Act guaranteed public school access. And eventually, we get the big one, the Americans with Disabilities Act in 1990. But as we all know, writing a law is very, very different from actually enforcing it. For 4 long years after Section 504 was passed, the government completely failed to issue the regulations needed to actually implement it. The law was on the books, sure, but it was essentially meaningless without rules on how to enforce it. And the disability community was tired of waiting. And this brings us to literally one of the most incredible moments of direct action in American history. In 1977, advocates launched coordinated sit-ins at federal buildings all across the country, demanding those Section 504 regulations finally be signed. The most prominent one happened in San Francisco. Activists, many with significant physical disabilities, occupied the federal building for 26 grueling days. To this day, it remains the longest nonviolent occupation of a U.S. federal building. The authorities tried everything to force them out. They shut off the hot water, they cut the phone lines, but the protesters adapted brilliantly. People inside who knew sign language would literally sign out the windows to supporters down below just to communicate their status and their needs. They slept on floors, helped each other with basic daily living activities, all without accessible facilities. It proved exactly how far these activists were willing to go to force the government to recognize their humanity. Ultimately, it worked. The government relented and signed the regulations completely unchanged. And this brilliantly illustrates the massive ideological shift that had just occurred. Organizer Kitty Cohn summed it up perfectly. She noted that this was the first time disability was truly looked at as an issue of civil rights rather than an issue of charity and rehabilitation at best or pity at worst. Section 504 firmly established that exclusion was no longer just unfortunate, it was unlawful. All right, moving into part 2, the Capitol Crawl and the Americans with Disabilities Act of 1990. So, Section 504 covered federally funded entities, which was huge. But what about private businesses? What about public transit? By 1990, the ADA had been drafted to address exactly this, but it suddenly stalled out in Congress. Public transit companies were lobbying hard against the strict new accessibility regulations, and they were slowing the whole process down. Activists realized they needed to take dramatic direct action once again. Protesters gathered at the base of the United States Capitol. Dozens of individuals tossed aside their wheelchairs, their walkers, and their crutches, and literally began physically pulling themselves up the 100 stone steps at the Capitol building. It became known as the Capitol Crawl. Among them was an 8-year-old second grader with cerebral palsy named Jennifer Keelan, who boldly declared she would take all night if she had to. As activist Michael Winter said, we had to be willing to fight for what we believed in. By forcing lawmakers to watch them drag themselves up the stairs, they made the daily struggle against physical barriers completely impossible to ignore. And the action worked. President George H.W. Bush signed the ADA into law in July of 1990. The really crucial point here is understanding just how sweeping this legislation was. The ADA is broken down into titles that mandate change across almost every facet of American life. Title I is all about employment, strictly limiting discrimination and requiring reasonable accommodations. Title II mandates access to local and state government services, as well as public transportation. Title III is massive. It covers public accommodations. That means your hotels, restaurants, private schools, stores, and care providers all must remove architectural barriers where readily achievable. Title IV ensures functionally equivalent services from telecom companies for people with hearing and speech impairments. And finally, Title V contains provisions protecting those who actually exercise their rights from retaliation. When we look at a list like this, we're seeing the direct legacy of those sit-ins and that Capitol crawl right in our daily lives. Ramps, video captions, accessible transit, modified bathrooms, and the 504 plans that provide educational accommodations to millions of kids in public schools today. These aren't just convenient features. They are the physical and societal manifestations of a century of hard-fought civil rights legislation. But if you think the story ends there, with everything permanently fixed and settled, well, the reality is much more complicated. Which brings us to our final section, modern legal battles, the Arc of Peril. The protections afforded by Section 504 and the ADA are absolutely not settled history locked away in a vault somewhere. They're actively being debated in the courts right now. To give you an idea, let's look at 2 recent decisions from the Supreme Court's 2024-2025 term. These cases show just how complex and constantly evolving the interpretation of these laws really is. On one hand, you have AJT versus Osseo area schools. Here, the Supreme Court ruled in favor of students, deciding that they don't need to satisfy a heightened standard of bad faith or gross misjudgment by a school district when seeking relief for education discrimination. That's a clear expansion of protection. But on the flip side, in Stanley versus City of Sanford, the court ruled that the ADA actually does not permit a former employee to sue over discrimination regarding post-employment benefits. So the boundaries of how far these civil rights protections extend and exactly who they cover in specific scenarios are being heavily negotiated in the legal system at this very moment. And it goes way beyond just individual interpretations. There are foundational systemic challenges occurring today. Advocacy groups are mobilizing once again, rallying under banners like Protect 504. Why the urgency? Because there are currently high-stakes political and legal challenges being mounted that could fundamentally alter how disability rights are enforced at the federal level. Right at the center of this is a modern lawsuit known as Texas versus Kennedy. The attorneys general of 17 states are suing the Department of Health and Human Services. Their core argument basically boils down to a debate over federal authority versus state sovereignty. These states are arguing that newly updated regulations for Section 504 exceed the federal government's authority and infringe on their rights as individual states. Furthermore, they are actually asking the court to declare Section 504 itself unconstitutional. Now, if this lawsuit were to succeed, even in part, it could severely curtail the federal government's ability to condition federal funding on compliance with these civil rights laws, which, as we've learned, has been the primary mechanism for enforcing disability rights since 1973. And we have to remember, enforcement relies entirely on the capacity of those federal agencies. According to advocacy groups tracking these changes in 2025, there are some really significant institutional shifts underway. The Department of Education is facing dismantling, while the Department of Labor and the Office for Civil Rights are seeing staffing cutbacks. The Equal Employment Opportunity Commission, which handles workplace discrimination, is currently operating without a quorum. On top of that, the Department of Justice recently withdrew 11 ADA guidance documents that were meant to help businesses comply with the law. Because enforcement of the ADA and Section 504 relies so heavily on investigations by these specific agencies, structural changes like this have major implications for how effectively these civil rights can actually be protected out in the real world. Which leaves us here. The history of disability discrimination in the U.S. is undeniably a story of incredible resilience, moving from forced institutionalization to the guaranteed right to public participation. But the very mechanisms that secure those rights are under active debate right now. So I want to leave you with this question. As we look to the years ahead, how will this delicate, ongoing legal tug-of-war between federal civil rights mandates and state sovereignty actually shape the future of accessibility for all Americans? The arc of progress has been long, but the story is far from over. Thank you so much for joining me for this explainer, and I encourage you to keep looking closer at the structures that shape our world.